this out for training, so we try to keep up on the latest things. Our focus is to get you what you need to know that would lead you right up to the attorney's door. So we'll get you everything you need to know before you reach that stage. We're not attorneys, so we can't give anything that could be construed as legal advice, but there's a lot we can show you. And I'll quickly review some of the things that we do in the appointments. Typically the appointments focus on either patents or trademarks, but today I'm going to glom it all together and we'll try to get an overview of as much as I can cover today. One of the first things I want to show you is that to make an appointment with us, you would visit the Denver Public Library's website. It's denverlibrary.org. And hold on, I'm still getting used to Roger's laptop here.
I just want to get this mic.
Oh,
Maybe we could put it on your other side, or
we could try. Yeah.
you want to sit there?
I don't know if I should. I could sit. Would you prefer that?
Yeah, it might be.
All right. Well, I'll sit. I don't think I've ever given a talk sitting before, but here, this will be fine. So, if you visit denverlibrary.org and go to the bottom of the page, you'll see a link to patent and trademark appointments. And click on that; it'll give you a lot more information. Plus, it'll bring up the page that will. It's a form, and you can put some information and tell us a good time for scheduling, and we'll set up an appointment for you. While I'm down at the bottom of the page, though, I do want to show you something else that we have. You'll notice that under Research, there's a link to Databases A to Z. And if I click on that and go to Databases A to Z, I want to take you to what's called the Legal Information Reference Center. You can access this from home using your library card. So it's another reason to get a library card. I'm going to click on Legal Information Reference Center, and at this point I'll put in my card number.
It has to be a Denver Public Library card?
Yes. It's a licensed database that requires us to give access through the card.
Non-Denver residents can obtain one?
Anybody can get a Denver Public Library card that's a state resident, and we're pretty easygoing even with out-of-state residents as long as there are certain requirements set up. So when you're on this page, there's a link to patents, copyright, and trademarks. And these are going to be links to books on certain topics. So I'm going to click on patents, and I'm just going to show you an example. Patent yourself is a great place to start, but you may have noticed there are books on trademarks and trade secrets and so forth. But let me just open this up real quick. You'll notice that it comes out and it's kind of backwards. I don't know why it's set up. I think it's a glitch. But if I open up any of them, you'll get a table of contents on the side. And you can read the book, full text, and everything that you would need to get started is here. I started with Patent It Yourself because that is by far the best book in this collection. It's been updated recently, so it has all the changes from the American Invents Act, and everything you would need is in this book. There are also books on trademarks. There are copyright as well. We're not going to talk about copyright today, but I just want you to know all that stuff is there. In fact, there are materials on legal issues for businesses. So once you get your business started, that's another good place to find information. We're going to spend most of our time today on the USPTO site, the United States Patent and Trademark Office site. What we do is we show you a little about what the website has to offer. Starting with patents, we show you a little about the overview of the process. We show you about some resources that our inventors have. And we'll go into more depth on how to search for what's called prior art. Prior art being any previous reporting of this discovery, your idea. So if that prior art exists, if your idea has already been disclosed to the public by someone else in any other time period, then you can't get a patent on it because it would fail the novelty requirement. The example I like to use, even though it's not from the US, is Someone wanted to get a patent for filling a sunken ship with ping pong balls, but was refused because it appeared in a 1949 Donald Duck cartoon. So that's how strict they can be. And I think that was actually in Denmark, but it would be the same criteria in the US. They wouldn't care. I will start by just reviewing a few things that are under the quick links on the side. A lot of what you need is going to be here. For patents, on the left-hand side, you have PatFT and AppFT. These are the databases. So PatFT will allow you to search for patents that already exist, and AppFT allows you to search through the applications that have been posted. All of those count as prior art. One of the great things about coming into the Patent and Trademark Resource Center at the library is we also offer access to Pub East. Pub East is the software that the examiners use when they do their searching, and in 20 different ways it is better and faster and easier and more efficient to use than PatFT and AppFT. But if you're at home and you want to get started, this is certainly a way to do that. The forms that you'll need are also available here. You'll notice EFS Web. This is for the electronic filing. Now, when it comes to patents and trademarks, we do recommend that you get an attorney. So you may not spend too much time doing the electronic filing, but I want you to know it's here. Once you've filed, you'll get a receipt back from the patent office that'll have a serial number that you can use to put into something called private pair. And private pair is a way to check on the status of your application. The patent process can take a long time. So one of the things that's nice about private pair is it will give you an update on what's happening on the patent office's side. So for instance, on a given day, maybe it only will say that it was assigned to an examiner, but at least you'll know that progress is being made. Once the patent has been made public and put on the database, you can go to public pair and get a listing of all the transactions that happen between the examiner and the inventor. It will give you other information which we might have a chance to go into a little bit later. Some of the things we don't talk about as much with our customers are links on paying maintenance fees, but I'll just mention that once you've been granted a patent at 7 and 14 years, after that you need to pay maintenance fees to keep it going up to a maximum time for 20 years for a utility patent. You can get a design patent and a plant patent for 14 years, but I'm not going to talk too much about that today either. PTAB, I'm not going to talk much about that today either, but that's when if your patent gets rejected or it gets challenged, you can find out more about the appeal board here. And you can look up who owns a given patent and find out where it's been assigned. And there's more on classification, but we're going to talk about that more later. And finally, everybody wants to know how much it's going to cost. Here is the link to fees. Let me open that up. And I'll show you that this is also the same place to look for patent fees and trademark fees. Can everybody see this okay? I don't? Okay, good. Let me open up patent fees and scroll down a little bit, and you'll notice that there are 3 columns. And in 2011, there was a bill passed called the America Invents Act, and they created small entities and micro entities. And if you make less than about 150,000, give or take, a year, and you don't have 4 previous patents, and you're not going to assign your patent to someone that doesn't qualify as a micro entity, you might be eligible for the micro entity status, and that means 75% off the normal US PTO fees. It's a great deal. Definitely take them up on it. Let me go back and also show you very quickly the trademark fees. They're here too. We'll talk about trademarks separately, but I just wanted to show you what that looks like. Oops. They're here. And we'll go into a little more detail about that later. So let me go back to the main page. By the way, I'm not used to using Internet Explorer, but I will hopefully not stumble too much. And on the trademark side of this, we have TESS. That's the database to search to find out if there are existing trademarks that are a little too close to yours. There is TEAS, which is the online filing, the electronic filing for trademarks. The TSDR is just like PAIR, where once you've applied, you'll get a receipt back that has a serial number that you can use to check on the status of your application. In addition, you can look for trademark applications that have been put in by competitors and see maybe find a few tricks about what they did to make their trademark successful. And again, there's a trial and appeal board for trademarks, ownership, and so forth, but I'm not going to spend too much time on those. Typically, when you're at the point where you need that information, you're going to be working with an attorney, and that's really out of our hands. But there's much more I can show you. Let's start with patents today. I want to start with inventor resources. And if I open that up, it will take us to this page. There's a lot here. There's a lot of general information. You can find general information on patents and trademarks. I know it said inventor resources, but it's a good place to look for trademark information as well. But we're going to go under education information, and tucked away at the bottom there is the U.S. map of state resources, and we're going to open up Colorado. And right there is Colorado. Feel free to stop me, guys, if you have any questions. And there are a few things I want to show you here. The first thing on the list is the pro bono referral service offered by the Mikasa Resource Center. They're currently located at 360 Acoma Street, which is just south of the hospital by Broadway. And they're going to be moving.
They're our late November 24th, I think. They're coming.
Oh, Jennifer?
Not to percent. Yeah, Jennifer's coming.
Nice.
She comes about once a year.
She'll have a lot to tell you. There's a lot that they offer there. It's much more than just the pro bono referral service. And I'm only going to touch on a couple of things they offer, but they have a lot of business classes to get startups going, get your financials in order, help you put together a business plan. In addition, when you're putting together your business plan, the library has another service, an appointment service called BizBoost. They'll help you get hard numbers for the demographics for your target audience. So it's definitely worth checking into. Let me open this up, and I'll show you a couple of things they offer now. It opens, we're opening it here to the pro bono referral service. There's a flyer that you can use. If you make less than 3 times the federal poverty guidelines, that's roughly in the mid-30,000s. And it ratchets up by the number of people in your household. You could qualify for this. If you qualify, it is the best deal in town. It's going to be free legal assistance throughout the entire patent process. I want to also show you that under business events, they have an event calendar. And I want to show you that on August 23rd, they have something called Business Legal Night. And it's from 6 to 8 p.m. There's a form to fill out. It says for small businesses owned by women and or minorities, but Jennifer has repeatedly assured me it's for everybody. And you fill out a form and you tell them what time might work best for you. And you will get a half-hour one-on-one time with an intellectual property attorney who can answer as many questions as you can fit into that half hour. So again, it's a great deal. Take them up on it if you can. In fact, if you think that this will work for you, sign up as soon as possible. They only have a limited number of slots. So do it from here and you can get set up. So I definitely wanted to cover that. When you get an attorney, and I really want to emphasize the word is when, not if. For patents, you really want an attorney. You'll want to make sure that they're on this list of registered attorneys. These are folks who have been licensed to practice before the USPTO. And I will put in Denver and Colorado, and we'll just take a quick look at what it looks like when you open one up. You'll notice you can click on practitioners currently accepting new clients. So this way you don't get a whole bunch of people who are working for corporations who will never see you. So here I can click on search, and I'll open one up at random, and we'll look at January Barrett. You'll see that there's not a lot of information here. There is her name, there's the firm she works for, her phone number, a way to contact her. Tells you if she's an attorney or an agent. It also tells you the date that she was registered with the USPTO, so it gives you a bit of an idea of how much experience she might have in the field. And again, is she currently accepting new clients? Yes, we specified that. So you'll want to make sure they're on this list. There's also a link to the Rocky Mountain Inventors Association. I don't know, you might want to check them out. And that's what I wanted to show you under Inventor Resources today. The other thing that I want to show you under this patents menu is the process overview, and that's where we're going to spend most of our time. One of the first things the first thing they have on the list is basic information. What are the differences between patents, trademarks, service marks, copyrights? All of these things, they go into some detail, so if you have any uncertainty, they'll spell it out for you. But we're going to spend our time with step 2, but before I dive in, I wanted to show you the Inventor Assistance Center. Now, the USPTO considers the application process to be a legal process. So at the library, we can't help you with the application. You wouldn't want us to. We're not attorneys, and it could be against the law. We might be accused of practicing law without a license. So we can't do it. But there is the Inventors Assistance Center, and one thing they can do is they can assist you with the forms needed and with filling out the forms. And the reason they can do that is because it's staffed by former examiners. So these are folks who have been doing it forever. And it's a toll-free number. They're open 8:30 to 8 on, that's DC time, so it would be till 6 o'clock our time. And it's right there, the 1-800 number. So that's always there for you. And let me...
See there any people tackling trying to do patents without attorneys?
Don't recommend it. There are a lot of reasons you want to have an attorney. One of the first things that they're going to do is they're going to do a search to make sure that this idea doesn't already exist. Roger will have endless stories for you about the things that he's gotten back that have been, that would look like a rejection for you, that would require an attorney to get you back on track. And another thing they're going to do is they're going to help you write the claim. But the claims are where the rubber hits the road with a patent. This is what describes what constitutes infringement on your invention. So you want to make sure that you've got the coverage as broad as possible and as carefully written as possible. And another major thing that an attorney will help you with is if for whatever reason your patent gets challenged anytime in the future, they're going to be able to defend every word and phrase that gets challenged. And very often it comes down to a word or a phrase that you have to defend. So it's very important to have an attorney for these things. And boy, Roger can certainly say a lot more on that. Now, step 2 is determining if your invention's patentable. And there are essentially 3 criteria. There's a 4th, but I think the 4th is kind of obvious, but I'll mention it anyway. But the 3 main ones are, it has to be novel. In other words, nobody's had this idea. It doesn't mean that there's a patent out on it already. It means that it didn't appear anywhere, in a magazine, in a journal, in a conference, in an advertisement. It just doesn't exist out there. It has to be a new idea. The second is that it has to be useful. I've never had anybody come in with an idea that didn't follow that criteria. But the example I use is you couldn't get a patent for the pet rock. And the third criteria is that it has to be non-obvious. And that's a bit of a fuzzier term, but essentially what it means is that somebody who's familiar with the state of the art in the field would look at your idea and see that that is a creative jump. So in the 19th century, the audio engineers didn't see the telephone coming. That was a creative jump. But if you were making salt to de-ice the roads and you changed it from sodium chloride to magnesium chloride, a chemist would roll their eyes and say, well, that's obvious. Of course it would do that. And they wouldn't be able to, that would fail the non-obvious criteria. The 4th criteria, sometimes I forget to mention, is that you have to be able to write it out in a way that spells out your idea in the patent itself. Because essentially what you're doing is you're exchanging public disclosure of your idea for infringement protection for that period of time that the patent covers. So it's a bit of a trade-off there. If you don't feel that you can disclose your idea for whatever reason, then you might want to look into other forms of protection like trade secrets. And recently the government is looking at a Defend Trade Secrets Act. Did it pass, Roger? Did it pass this year? I don't remember if it passed, but there will be stronger protections for trade secrets.
That's kind of a weird issue because it's actually, trade secrets law is state by state. But I don't know what's
Okay.
and stuff. But it's the trade secret is just briefly, it's what you have before your patent pending. Okay. Multiple people can have valid trade secrets as long as they haven't taken the information from each other, even on the same invention. So everyone's got a trade secret, as long as it's secret.
Right.
But as soon as one person somewhere in the world patents it, it kills all the other trade secrets because it's gone public. So that's why it's a very fragile thing to keep. You're constantly a threat of getting usurped.
Well, presumably the act will allow there to be more actionable measures you can take against people that reveal your secrets. And trade secrets include much more than just your secret recipe or your...
Marketing, sales data,
Right.
financial data.
Oh, yeah.
It's anything.
Right.
Price lists,
Yes.
stuff like that. But usually, the advantages of trade secret, just not to go off too much, is that it can last forever. It doesn't have an expiration. Covers anything. And is typically good for things that the public can't decipher easily, because reverse engineering is legal on trade secret. So if I have a chip in this laptop and my trade secret is the manufacturing process of putting these difficult materials together, that's a pretty good trade secret, because that's hard for the public to unwind it.
If you could reverse engineer a chip, you can already make a chip.
Yeah, right. And you already know how to.
Yes.
But it's embedded in a product, so that's a better trade secret.
Yes. And there are details in chips that they do keep secret. One last thing I'll mention on trade secrets before we go back to the talk is that if you are working with trade secrets, typically you'll get people who are working with you to fill out non-disclosure agreements. And you'll want to get an attorney to tailor that agreement to be spot on for your needs. There are templates out there that you can use, but you really want to tailor it to be airtight.
Because the threshold, like I say, two people can hold the same trade secret as long as they haven't stolen from each other. That's legal. A trade secret can be a compilation of publicly available items put together in a new way. That is a trade secret, even though each individual piece is public. So the threshold's very low. But it's like you break the shell of the egg if it goes public in any form. And that's like if you were to group like this and you talked about it and you didn't have everybody in the room under a confidentiality agreement, you've made your public disclosure.
It can get ugly. In fact, talking about public disclosure, that's another thing I want to mention. Before you get your, before you put the word out on your idea, you'll want to get a provisional application in the mail, or in this case, through electronic filing. That creates a filing date to protect your idea. Let me go into a little more detail about that in a sec, but what I wanted to say, hold on. I just wanted to mention that in this step 2 also there is the most important part of what we're going to talk about today is the 7-step strategy. And that talks about how do you search the patent database to find out if your idea exists. What did I want to say on provisionals? The American Invents Act changed the rules a little bit in 2011. It used to be set up in such a way that you were protected if you were the first to create an idea. And if somebody else patented it, you might have to go through a lot of work to defend your early, your creation date and your priority over it, but it it was designed to protect you in that way. However, they've changed it. Now it's first to file. So what you want to do is you want to get that paperwork in as quickly as possible. And what they've done to make it easier is they have what's called a provisional application. It allows you to get something in the mail very quickly. It costs $65 if you qualify as a microentity, and most people I work with do qualify. I can't tell you if you do because it's considered a legal determination, but let's just say that most people who come in do qualify. And if that is the case, then for $65, you've got that in the pipeline. It gives you a filing date, and you have 12 months with no extensions to get that non-provisional application into the patent office. And that's when the process really starts. The provisional is relatively easy. You don't have to sign the oath. You don't have to fill out the claims. There are a lot of things that are easier about it. The important thing to keep in mind, though, is that you don't want there to be significant changes between the provisional and the non-provisional, because the patent office might perceive that as a different invention. And so you have to be careful with that.
At what point are you patent pending?
Once you've gotten that provisional in, you can say it's patent pending. So from that point on, you do have a little more protection when it comes to disclosure of your idea. And I wanted to mention also, this is what I forgot before, that the US has a 1-year grace period where you can disclose something and you have 1 year to get it in the works. But keep in mind that that grace period doesn't exist pretty much anywhere else in the world, just in the US. So that if somebody from Lithuania heard your idea, they could get a patent on it before you did. And that can get ugly, especially if you want to have international protection through the Patent Cooperation Treaty and other things. So it's still a good idea to keep it under wraps until you've got that provisional into the office.
Well, even if you have a non-provisional patent, they can still get a patent on it in France or whatever, right?
Not if they play by the rules.
Who's got file date priority and who potentially had access to the other's information.
Okay.
But
So,
that's,
in a perfect world, they would be able to.
it's, yeah,
Right.
it's such, like Steve said, it's a lot to go through to prove those issues, so it's better to just keep it trade secret, file it, and then publicly disclose it.
Yeah.
So
It's
one of
just
the things I was
cleaner.
gonna ask was, while you have that patent pending, you can potentially sell some units.
Or at least get a sense of how the market is, get some feedback on what people like about it.
But then you're opening yourself up to that European threat too. at the same time.
Well, if they will remember, once your non-provisional is in, it will appear in the applications applications database. So that counts as prior art. But yes, when it's still a provisional, you got to still be a little careful. But if somebody tries to file in the U.S. and your provisional's in place, you are protected. That provisional is there to create the filing date for that idea, for that unique invention. So, you got to hope for the best. But
There's always a little risk because worldwide applications, non-provisionals, are kept secret for 18 months. So
yeah,
you could file Jan 1 and then 6 months preceding to you, someone filed the same invention, you would know. And
That's right.
so that there's always some risk. But
Goes both ways.
That's the window, is 18 months.
yeah. So we'll talk a little more about searching today. Again, I'll point out that the focus that we're going to have at the library when you come in for an appointment is we'll show you how to use PubEast to do the searching. PubEast is very fast. It's a quick way to go through this. I'll show you how to do it this way, but I will recommend that you do come in and we'll show you how to use it. The 7 steps are what the USPTO recommends that you use to do your searching. We're going to revise it a little bit. The first step, though, is a good step. You have to brainstorm terms to describe your invention, and this can be the hardest when you're just starting. It's not so bad when you've done some searching, you've found patents that are close, because then you can look at the terms people have used, you can look at the classifications they've used, and you can use that information to zero in a little faster. But when technology is new, the terminology can be all over the place. This wasn't called a computer mouse when it came out. It was an XY position indicator. You know, I wouldn't have thought of that. Nobody would think of that. But that's why you have to try to open the field as much as possible to any way to describe your invention based on its purpose, its composition, and how you would use it. So if I was to invent a transparent umbrella, which I've used as an example forever, you would, you'd use umbrella, you'd use cover, you'd use transparent, you'd use weather, you'd use rain, you'd use climate, whatever you can think of that might describe how this might be described, at least in an early stage of its use. Now, if I was to do the search in the database using umbrella as a keyword, I would get 30,000 hits. You don't want 30,000 hits. So what they've done is they've created classification numbers to do your search and to pin it down much more efficiently. So what they recommend is using the USPTO site to do this search, and I don't recommend it. There's an easier way to do this. We're currently using classification numbers that are, it's the Cooperative Patent Classification System, or CPC. You're going to hear CPC numbers again and again when it comes to this whole process. And when you're looking for the CPC numbers that are relevant, you're going to want to do a search that is as easy as possible. And I think the easiest way to do it is using the European site rather than the US site. I'm sure the US site will get better eventually, but it's not as good as the European site. So if you go down to step 7, you'll see a link to the European site. It looks like eSpaceNet. I know it looks like that, but it's pronounced as SpaceNet. And that will take you to their webpage right here. And the great thing is there's just a simple little click right here. You can click on classification search, and that will begin the process for you. And here are the main headings for the CPC numbers. I'm not going to talk about that too much today. I don't think you really need to know the details. But I can put in umbrella and hit search. And the number of stars tells you how relevant it thinks the results are. So 2 stars looks pretty good. I'll give it a shot. And it is about details of umbrellas, so that looks promising. So I'm going to open it up. I'm going to click on it. And you're going to see a number of subheadings. Now, the dots don't look obvious when you look at them, but they're really subheadings. And if you click on this little toggle switch up here, that the toggle tree, it actually becomes a little more obvious how the subject headings are broken down. So I'm going to scroll down, and there are covers.
I interrupt real quick.
Yeah.
Does their dot system follow what we had for the?
It's the old dot
Good.
system, yeah. Yeah, that's why they left it there instead of, I'm sure that's why they left it there instead of changing it by default to the toggle, because it makes much more sense when you look at it with the toggle.
Oh, yeah.
So I'm pretty sure that's what they're doing. So if this looks like it might be close, here are covers. So umbrella covers, yeah, that's pretty close. So if you can click on the D button, and what that stands for is it'll open up the definition view. And you can look at that and say, all right, well, these are umbrella covers. All right, that's not too far off. If they also can make suggestions. Maybe you were thinking about detachable covers. And if that's the case, you want this classification number. So that's how you can use this. So I'm going to cut and paste this. But I'm going to cut and paste this. But you don't have to, you can still cut and paste this, but what you'll want to do in the process is you'll want to keep notes. You want to keep track of all the numbers you've used, because any relevant number is going to end up on your application as something that you can tell the examiner you've already searched. So that'll show that, we'll go through this a little more as I show you what a patent looks like.
Now, when you go through this process and you try to search it yourself, what more will you get from a professional?
Okay, excellent question. First thing that you want to do is see if somebody has your idea. And the reason you want to do that on your own is because you don't want to pay an attorney to find out that somebody has your idea. If you can find it, it would be disappointing, but at least it would be free. So that's one thing. The second thing is, if you walk into an attorney's office, the first question they're going to ask you, or pretty much the first question is, have you done a search? And I think it'll be good for your experience with the attorney to go in there and show them that you've not only done the search, but that you know what you need to know about the process, that you're really in there to have them dot I's and cross T's rather than just saying, I have an idea, and it'll work in your favor. So between that book I showed you, the full text book, and the work that you can do ahead of time, this will all help make it a more successful process for you.
So when you pay for a professional search, you do a lot more than this?
Well, they're going to do a similar search. What we're doing at this point is just the beginning, and I'll show you how it works. We'll use the web-based one, although usually I use PubEast to do this, but we'll figure it out. So we've done step 2. We've found CPC numbers. We've done step 3. We've looked at the definition view. And now the next step is to do step 4. Let's go into the database and search. You'll see that there is a column here for the patents database and a column for the applications database. That means you have to do the search twice. Another reason to come into the library. PubEast allows you to do both at the same time. So definitely a good reason to do it. I'm going to use a quick search just for this purpose, but advanced search is not that much harder. It's just a way of, it allows you to combine things in a little more complicated way as your searches start to get a little more complex. Yeah.
The EPO search, that'll pick up publications and patents, right?
For EPO and JPO?
Yeah.
Yeah, it definitely will. And you'll notice that when I pasted it into this little search box, it got rid of the space. I know this is like a little detail, but that space there, if you left it in there, it would give you 0 results when you search. So get rid of the space. And then down here, you pick current CPC classification. And I'm going to hit search. You'll notice that this goes back to 76, but when you're doing CPC searching, you can go all the way back to 1790. So you'll get back patents that were signed by George Washington if your idea is old enough. I generally tell people if your idea involves GPS, then yes, you don't have to worry about going past 1976. But if it involves, some sort of new farm tool, go back to 1790. I'm going to hit search now, and you'll see that instead of 30,000 hits, we got 288. So not bad. It may still feel like a lot, but that is much more like what you'd expect to get. So let me open one up, and we'll go through the parts of a patent. Let me open up this safety sign system. You'll see that it starts with the patent number. It's on the top right. That's the number you see associated with any patent. And this is the date that it was granted. And here is the title of the patent. Here's the abstract, a little information on the inventors and so forth. And as you scroll down, you'll see other classification numbers. So you may go back to SPOSNet and put this number in and find out, well, that's umbrella handles. I don't care about that one. But you may find others that overlap with your subject a little bit, and you may want to go back and search that. The nice thing about this, and this applies for this database as well as PubEast, you can tell it to give me the new results, but don't show me any of the old results. So that's pretty nice. And I'll show you how to do that in a sec. You'll get a list of patents that the inventor referenced as prior art, also other applications. These are inventions where the inventor said, well, these are close to mine, but mine is different, and the rest of the patent will be devoted to showing you why mine is different. It will also show you referenced by. And if I click on that, that will give you another list. Sometimes it's much shorter, especially if it's a new patent. And these are ones that happened later on that referenced this patent. So you get backward citations and forward citations. And all of those could be relevant. Maybe maybe this patent's not yours, but one of these might be. So you'll want to go through those. There is a very quick way to do that with PubEast, but you can do that here by opening them up one by one and checking them. Let me show you now how to actually look at the patent itself. So here we have the result. Oh, don't, behave. The display driver stopped responding. Well, I'm going to ignore that. So let's take a look at the patent itself. We can click on Images, and it will open up the patent. If it behaves, come on. Here we go. By default, it starts with the front page. So to open up the rest of the pages, you can click on Full Pages here. And for our purposes, I'm going to do that now because I want to show you a little about the whole patent. So again, you've got the information that I showed you before, except that it's arranged in a slightly different way. There's the inventor again. Here are other classification numbers to search in 51, 52, and 58. Now, you don't have to bother with those if you look at the abstract and you look at the drawing and say, this isn't like my invention at all. But if it is close, then you'll want to get other classification numbers to search. Now, the goal is to eventually keep trimming down the results until you don't have you're going to smaller and smaller search results. So when you're at that point and you've gone through them, you could say with some confidence, yes, I've searched through this, I can't find anything. It doesn't mean you're done, but it does mean that you can go to an attorney with some much more confidence and say, look, I've done this search. If you can find something, great, but we're ready to get started. So let me go to the next page. Oh, actually, I'm sorry. Let me show you a couple of other things. Fields 51 and 52 are the classification numbers that the inventor thought were useful or relevant. And field 58 is where the examiner said, well, those are good, but I think I should check I should check these. And these are numbers that you should definitely pay attention to. The examiners live and breathe this stuff. So if they think these are relevant, you'll want to check them. Here are the list of prior art patents again, the references cited. They have a limited amount of information they can put on the front page. So in this case, they're continued, and you'll always see them on the second page. There's the rest of the list. And then here's your abstract and your drawing, your main drawing. Very often you can tell at a glance, this abstract and this drawing will tell me, is this my invention or not? There are several pages of drawings. You're going to see little numbers pointing at things. These numbers all get spelled out later on in the patent. So you can essentially recreate the invention. As an aside, I heard a magician talking about a magic trick he had come up with, and he had done a patent for it. And I actually found the patent. I don't know if you've seen this, but it's this men and women who do this act on stage where the woman changes her clothes in a flash. There's one scene where the magician will throw a big ball of confetti, and as it falls down over her, she changes her clothes it can't take more than a second. And he mentioned there's a patent for it, and I actually found the patent. It tells you how to do it. I wouldn't want to be that woman. I think there's a lot of stuff going on. I worry about it a little bit, but you can actually find stuff like that in the patent database. So here,
Watching America's Got Talent?
I think it was on that actually.
How did it work? Now you're killing me.
Her dress is full of wires and all sorts of things. She's got layers of clothes on. It's a crazy invention. I'm amazed that they can smile and look confident while they do it. But it's also breathtaking when it works right. It's a beautiful thing to see.
Yeah, so stuff like, visual effect. I mean,
Yeah.
Holograms, like sometimes on cups and stuff, they do multiple layers, and
Yes.
it has a 3D look, and you can angle it, the picture change. I mean, that's patentable
Yeah.
stuff.
Most magicians rely on trade secrets, of course, because
But
public
then-
disclosure
yeah,
doesn't
as
work in
long
their
as
favor.
it's not disclosed.
Yeah,
you
yeah.
have to-
Yeah, they're at more risk, of course, but I wouldn't want to mess with the magicians. They you want them on your side. So we're back in text again. We've gotten through the list of drawings. There's the background to the invention. That could be helpful. The summary of the invention is a little more spelled out than the abstract. It's a good place to check. The brief description tells you what each of those drawing pages were about, and the detailed description goes into essentially how would you recreate this invention, tells you what all those numbers are pointing at, and finally, at the end, usually it starts I claim or we claim or what is claimed is, and here are the claims spelled out. This is where you, if you find a patent that looks close to yours, the abstract and the drawing kind of remind you of what you're working on, you'll want to go to the claims. It'll tell you, exactly what constitutes infringement. If their idea has, claims A, B, and C, and yours does A, B, and C, you're kind of done. You found prior art. You're not going to be able to get a patent on that idea. But if your idea does A, B, and C, but it also does D and E, you might be able to go to an attorney and say, look, mine does D and E. I haven't found a patent that does this. So it's the beginning for you. And then you can get an attorney's help to help, fill out those claims a little bit more to make yours a unique invention. And I know I'm oversimplifying, and I'm sure when Roger hears me say this, he's thinking, oh, it's more complicated than that. And it is. But that's essentially how you can look at it as an amateur. And
You might mention the pair.
Yeah.
Are you going to cover the pair?
I want to mention that pair can be useful when you're doing your search. Sometimes when I get somebody who really is not comfortable with the computer and they are not quite sure how to do this, I don't go into pair as much at first. But what I can tell you is that if you find an invention that is close to yours, you can go into pair, that public pair that talks about all the information that between the examiner and the attorney, and you can actually look up the examiner's search strategy for that invention. So if it's close to yours, you can use that information and do a much more informed search, and it will help you.
Especially, if it's fairly recent too.
Yes,
The last
yes.
1, 2, 3 years.
Exactly. If I get a chance, I'll show you pair. I want to make sure we cover a few things, though, but we're moving along pretty well. Now, if I have, let's say, all right, I've looked through that CPC number, and this one's not too far off. It's transparent. I don't know if it's considered a window or not, but I'll grab this one. Oops, let me copy that one. Oh, you know what? Hold on. Let me show you how to do this a little differently. Hold on just a sec. I don't like Internet Explorer as much, Roger. I might, I'll show you guys a couple of things. Let me cut this and put it into this one, and I'll show you a trick. So here we have that other number. So I'm going to copy that, and I'm going to put it into the database here. And I'm going to tell it that I want to search this new number and not the old number. So with this trick, you can pull up the CPC numbers with this, the inventions with this new CPC number, but you'll leave out all the ones you've already looked at with the old number. So it's a quick way to trim out any stuff that any old territory that you don't want to have to go over again. So it's a nice trick. And as it gets a little more complicated, as you get more and more numbers, you can use the advanced search. I don't want to suggest that advanced means it's really harder. Essentially, it looks like this. If I put in CPC / and then that number, and then I can put and not, and then CPC / and the old number. You can keep doing that for more and more numbers, and you can do a more sophisticated search as you go along. We can talk about that more if you do have questions about using advanced. I'd be happy to answer questions about it, but I'd like to move on a little bit to cover some other topics.
Is there a limit on how many of those fields you can string?
There is a limit in the number of characters you can fit into the search. So yes, after a while, it'll start to get a little out of control.
This is one of the searches you have to do at the library. You can't do this one.
No, everything I'm showing you, you can do at home. Now, the beauty of it,
On to that one, this is the basic.
the beauty of Pub East is that the restrictions I'm talking about now, the extra steps you're taking, you don't have to do on Pub East. So we can focus on just showing you how to get going on Pub East. And, you know, I'll probably, you know, go into a few details we didn't cover today, but you'll see that it is a little easier. So those are the ways you could search on the patent database.
Now, are these all the same databases that you pay your patent attorney to do the patent search? They're all the same.
Well, yeah, the free database and the Pub East are all going to the same place. And I can't speak to all the subscription databases out there, but as far as accessing the patent office's database, yes, it's going to be looking at the same stuff. Now, some of the other subscription databases might include more international searching and so forth, and you know, this isn't going to do that for you. Pub East, though, I should mention, also allows you to simultaneously search the European and Japanese patent office, and it'll pull up the abstracts, which are in English, thank goodness, and you can do that as well with Pub East.
Plus, you can see the figures.
Yeah.
But if it's, you know, a chemical or electronic,
Yeah.
that's not going to help you so much because you need to see the text. But on mechanicals, it's
Yeah, I have to point out that, yeah, Roger's right. I mean, I'm not really talking about doing pharmaceutical searching or, you know, it can get very complex. I actually had one person come in with pharmaceutical searching, and just to help her get off the ground, we had to find a whole bunch of other databases to find, you know, registry numbers and all sorts of things that we are not going to talk about today. So
You gotta be a scientist just to do it.
you do. You have to be a scientist. I'm not a scientist, but I do have a lot of science background, so thank goodness I was able to help her, you know, get started.
The lady that did my patent search, she can do those.
Yeah.
She can do that.
And then there is Google, for instance.
There is Google Patents, but you want to go here. This will do more for you. And as I showed you, you don't want to rely on keyword searching. You want to do these CPC searches. So
If they are on Google Patents, they are on here.
they are, yes, yes. Let me see, is there anything else I wanted to mention here? I think what I'd like to do at this point is essentially tell you that with Pub East and what I've shown you so far, this is about as far as we take you with the Patent and Trademark Resource Center. We give you a chance to figure out, is your idea out there? And if you have other questions, you know, we'll answer them as best as we can. We also have access to the folks at the patent office, so if we can't answer them, we'll try to get somebody there that can. There are a lot of questions that maybe I can't answer, but I can get answers for you. So that's one of the things that's essentially what we're there for with regard to patents. The next thing I'd like to talk about is the trademark side of the equation. So as I mentioned under quick links, you're going to see TES and TEAS and TSDR. We're going to not spend too much time in the quick links, but let's go over to trademarks. And one of the things I'll mention is that under Trademark Basics, it will give you a link to a series of videos the Trademark Office has put together that are dense with information that will answer lots of questions. They're also corny, so be prepared for that. But they thought it was funny. We're going to spend our time on the process overview. Just like with patents, there's a process overview. The first section will give you, again, some basic facts. Here's that video series I mentioned. A lot of that will help you, including information on getting your application together, which we can't help with. The first thing they want you to determine is, a little about your mark. Are you just getting a standard character mark? Are you just getting a trademark for the phrase or the business name? Or do you want to get a trademark that includes a logo associated, maybe the arches for McDonald's, the golden arches. The golden arches not only have a trademark for the arches, but the color associated with it, that very distinct color. Colors can be trademarked as well. I'm sure you've all seen pink insulation for your attic. The pink has nothing to do with insulation. It's just a color associated with it that is unique to that provider. And they've trademarked the color. You can trademark sounds. You can trademark there are motions that you can trademark.
And scent.
A scent, yes, you can trademark a scent. The sound trademark, the one that comes to mind are the NBC chimes. Maybe you've heard dun dun dun. That's been trademarked.
And if I'm making a boat and I use McDonald's yellow, that's okay. But if I'm making a restaurant and try to use it, I might be in trouble.
You might be in trouble, yes.
But it probably still would be, if it's famous.
Yeah.
If they consider it famous, they can stop all goods and services.
Even if it's a boat.
Anything.
Yeah, if they feel that you're in any way impinging on their target audience, then they're going to descend on you with a cease and desist. Now, one of the things that's going to help, well, let me back up. Let me go back very quickly and show you that section under fees. One of the things that they do, there we go. Okay, we'll come back to that in a sec. One of the things that they do with trademarks is they have different fees depending on how you register. Now you'll notice if you do a paper filing per international class, it's going to be $375. But if you do what's called a TEAS Plus application through electronic filing, it's $225. That $150 difference is there because they really want you to file electronically. They don't want to deal with paper. They want you to have done all the work as much as possible ahead of time. That's what TEAS Plus means. So what we're going to talk about are some of the things that they're looking for in that TEAS Plus application, so you don't have to worry about it as much. Again, we recommend working with an attorney who will do a lot of this work for you, but there's absolutely no reason why you can't do a lot of this work ahead of time before you go into the office. And then maybe discuss with an attorney, maybe should there be other classes? We'll talk about that more in a sec. So the next step is to identify which international classes your business fall under. So we use the Identification of Goods and Services database for that. So I'm going to open it up. By the way, I know I'm throwing a lot at you guys. I know that. Typically in an appointment, we just do patents or we just do trademarks. And even then, I have to throw a lot at you folks. But I will tell you what I tell everybody. Don't hesitate to make more appointments. You can make 20 appointments for all we care. You can make an appointment every week. You can ask the same questions 20 times in a row. We don't care. We just want to make sure that you're comfortable with the information. Because what this will allow you to do is have a much better handle on the whole process, and you'll know what's going on when you work with an attorney. You'll go in there with your ducks in a row. So let's say, for instance, that we're searching this Goods and Services Manual, the Acceptable Identification of Goods and Services Manual, which has no possible easy-to-remember acronym. So I'm just going to put in yoga. I don't imagine anybody here is working with yoga, but the important thing is I show you what comes up. And here, for instance, say you're selling yoga shirts and pants. The class number is 025. And if you put your cursor over it, it'll tell you that 025 is for clothing, footwear, and headgear. But say you're looking for yoga accessories. So maybe yoga blocks and yoga straps and whatever else they do in yoga. That would be, here it starts with games and playthings, but it's also gymnastics and sporting articles not included in other classes and so forth. Don't ask me how decorations for Christmas trees fit in there. I couldn't begin to tell you. And finally, if you're just teaching yoga classes, that would be 041. And, providing of training and so forth. And you'll see on the side the type is goods or services. These are all things they're going to ask in the application. And here, this goes into more detail. This is 041 for the class, but the type is 152. This is all information they're going to ask for in the application. So this is all here for you. And let's go back. Now, you may determine that you need more than one class. You're teaching yoga classes, but you also want to sell some yoga shirts on the side, and you've got a whole shelf full of yoga accessories. So you'd want to pay for trademark protection for 3 classes. That means $225 times 3. I know it sounds like a lot, but the goal here is to make it all worthwhile in the end, to make that trademark protection worth much, much more than the $775 you're going to pay in the beginning. In addition, you're going to want to make sure that you also have protection for your business. So people aren't going to confuse your business with another one. So that trademark protection is going to be there for you. The next step is to search the database, but filing basis is so straightforward, I like to jump ahead a little bit and just tell you what this means. When they ask you what your basis for filing is, they're really asking you, are you using your trademark in commerce already? If the answer is yes, great. You're using your mark. If you have the intent to use it, there's another form. You have 6 months to use it. It's a use it or lose it kind of thing. But you can get extensions. And I believe it's 5 extensions. 5 extensions. That takes you about 2 or 3 years out.
Plus the original, so it's
Plus
36 months max.
36 months. That's it. 36 months.
That you essentially can reserve your trademark.
Right.
Use it.
But it is use it or lose it. They want to make sure that these marks are being used. And then we can go into the test database. Now, test is a surprisingly sophisticated database. And I'm going to click on this. And there are a few things in it that I've never seen used in another database. And I'm not going to go into too many of those details. But when you come in, we have a cheat sheet by the workstation. And it has all the tips and tricks in it. And I could show you how to use them. Also, there is an extensive help menu for tests. And you'll want to look at it. It's a little long. I know you may not be prepared to spend an evening reading test help tips and tricks, but it will be useful if you want to start before you get an appointment. So let's go in and take a look at a basic word mark search. And I just heard about a business called Gibberish, and I'm gonna put that in here because I did find it, and I think it's sporting goods or something. And it's spelled like that, Gibbarish. And I'm going to submit the query. Now, it didn't find it, but that's a little strange, because I know it's in there, so I may have spelled it wrong. But it doesn't matter, I can put in...
For the J?
No, it really is like that.
Oh.
I'm pretty sure I got it right. But regardless, let's put in Timberland instead. I know they're in there. So here are the results when you put in Timberland. You'll notice that they list the trademarks as being live or dead. I should point out that dead doesn't necessarily mean that it's available for use. It means that they could have stopped paying the maintenance fee for it, because with trademarks, you pay a maintenance fee every 10 years, and you can keep a trademark forever. But you do have to pay every 10 years. There could be other reasons. Maybe they are still working out some details. I don't even know why it could be dead, but the point is, it doesn't mean that it's necessarily available. They may still have rights associated with them.
Like they pointed out last Tuesday, you gotta know why it died.
Right.
If it died simply because it wasn't renewed, then you might go after it. If it died because a big corporation filed an opposition and killed it,
Yes,
you
right.
don't wanna use it, because then they're gonna file an opposition on you, and you've wasted your money and time.
Exactly.
Do you have to file in more than one country?
You can. There's something called the Madrid Protocol that allows you to file in, it's somewhere around 100 countries now, give or take a couple. And it's not that hard to do. It's just an extra step. You pay a little extra money and so forth, and you can file in a lot of other countries at the same time. I'm not going to go into that too much right now, but I will point out that if you go to, let me just pull up the, if you go to trademarks, you'll see that there's a link to Madrid Protocol and international protection. And there's quite a bit of information there on what you need to do. It's not as hard as you might think. It's just a couple of extra steps. Actually, they try to make it as easy as possible. I have a little more trouble telling people about the many steps you have to go through to make the patents work, but with trademarks, it's not like that. The trademark system is fairly straightforward, and I think you'll find that that's true with the Madrid Protocol too. It's just a couple of extra steps. It's not that bad. And remember, the Inventors Assistance Center is there to help trademark seekers as well, and they can answer questions on this too.
So like if Nike did a trademark, but they didn't do it with the other,
China, say, for instance.
so China could use the Nike.
You bet. And China's kind of notorious for trademark infringement, and you know, you really, if you have any aspirations of going international, you'll want to get your trademark international as quickly as possible. And one of the nice things is that you'll get protection with the customs office, so imports and exports, they're going to be watching for trademark infringement for you. Now, nobody's going to do an infringement suit for you. You have to pursue that. But they'll act as a bit of a firewall for you when it comes to imports and so forth. So that will help. There is more information about that sort of international angle on the website. I'm not going to go into it right now, but if you want to make an appointment and let me know ahead of time that this is something you're interested in, we could pull up some more information. And of course, you know, Roger and other folks can give you some of this info. In fact, some of it's here too under IP policy and learning and resources, but we'll go into that a little later. Where were we? Oh yes. So here are some results. So I put in Timberland, Timberland Boot Company. Boy, that looks familiar. Let me show you what it looks like. I'm going to open one up. So here is the Timberland Boot Company. Here is the international classification. They're covered under 014. And here are 4 other classes for US that they're covered under. One of the nice things about looking at this, when you find competition that looks really close to your idea, you might get ideas about other classifications you hadn't even thought about that might be worth getting protection for. So maybe you were that yoga company that is teaching classes and you realize, boy, this yoga company's got clothes and they've got accessories. Why don't I go into that and, you know, cover it right from the beginning? So that's useful. Another thing, just like public pair allows you to look at all the information that went back and forth between the examiner and the inventor, the TSDR in the trademark side of the equation, which I'll pull up again. Let me see. TSDR allows you to go into the application for your competitors, and you'll find out not only what they did with their application, but you can look at what the examiner did to search tests and to search that database and see how they did a thorough search in looking for similar types of businesses. Now, one thing I should point out, that's the key here, is that the criteria that the trademark office is using is called likelihood of confusion. They are trying to find out if your attempt to get a mark for your business is going to confuse any potential customers. So if you're going to make auto tires and you decide to call yourself Cadillac Tires, Cadillac may not make tires. I don't think they do. But Cadillac Auto is not going to be happy, and you're going to get the knock on the door. However, if you want to make Cadillac dog food, you can, because nobody's going to think that Cadillac is making dog food. And there actually is a Cadillac dog food out there, to my surprise. So that's the way they're going to think about it. So they're going to look down on generic kind of titles, you know. The bagel store, they're not going to be too crazy about that. But if you ask for a name like Exxon, they're going to love that. That doesn't mean anything. It doesn't get associated with anything. That's very unique. And if you associate that with your business, they're going to have a very high likelihood of granting you that trademark, as long as nobody else has used that name.
How many registered trademarks are there in the United States?
Oh, man. It's a lot. I can't tell you off the top of my head. It's gotta be, well, I was gonna, maybe millions. I don't know if it's quite that much, but it's a lot. It's certainly hundreds of thousands. Yeah. Do you know off the top of your head?
Between close to 5 million.
5 million, yeah. And they go back quite a ways. Trademark number 1 came out of the 19th century. It was a paint company, and you know, the database is pretty good at covering all the trademarks.
Legally, they can last forever.
Right.
The only requirement is every 10 years you have to prove that you're still selling it.
Yeah.
Still active in commerce.
Yeah.
Otherwise, it can be released to somebody else.
Yeah. Yeah, they don't want people hoarding trademarks without actually using them. But if you're using them, you can use them forever. So a business name could be essentially in use for 1,000 years. They wouldn't care. So, let me close that. And
There's,
so,
I might want to point out something here, like Timberland is normally hiking boots, but you can see they've added goods and services of watches,
yeah.
backpacks,
Beverageware is a surprise.
So, and I first ran across this when I started in this, like Nintendo has got
Yeah.
coffee machines, you know. So they, the big companies, they'll start covering goods and services way outside of their norm.
Yes.
And that's the way they start to make themselves famous, and they can prevent others from doing like completely different goods and
Right.
services.
Right.
But don't they have to approve it by making a watch?
Eventually, like, they can reserve watches if this is approved, this one's still pending, they can reserve up to 36 months. But eventually, they're gonna show interstate commerce and watches.
Yes.
And this, if you take a trademark and you start doing lots and lots of classes, they get pretty expensive. They start costing a lot more than patent.
Yeah, they're charging you per class, so it does start to add up. And Timberland can afford it, but not everybody can. Let's go back. Now, opening these up one at a time can slow things down a bit. I just want to point out that there's a link here to image list. So if I open it, you can actually see the images and trademarks and so forth. So it makes it a little easier. And say,
You see the difference between a plain text filing and then they
Yes.
added unique font and
Right.
the little tree logos.
Oh, yeah.
So those are separate trademarks.
right, so I can open that up, and there's the information. Now you'll notice because it has a design, there are also design codes associated with that. So we'll talk about that next. Let me go.
Yeah, because if someone comes in and says, I want to do a design mark search, you're like, oh.
Yeah, well, it's more work, and I'll show you why. You'll get a sense of it very quickly. Let's say you have this idea, it's going to have a string of stars going across. And that means that you're going to be working on a design mark. And the first thing you need to do is go find the search code, the design search code associated with that. So we open up the design search code manual. And what some poor team at the USPTO had to do was classify every possible image on Earth. I would not want that job. But so here are the main headings. There's a way to do a keyword search, but it's probably a good idea to start with the general subjects if you can. So I was doing stars, so celestial bodies would count as stars. And stars and comets, they're right at the front. So I can go through these and I can look at some of the general areas. And here that's kind of like a string of stars. So, it's stars grouped in circles, semicircles, geometric figures. And they're coded in 010303. And Yeah, these are examples of them. And when we go into the database, we can then take that information, so 010303, and limit it by design code, and do a search. Now remember, this is everything that has stars. We haven't limited it in any way. And this is a good example of wanting to use that image list to look for similar things. But this is just an example of what comes up when you use a design search code. So, some of these have circles, some of them have strings of stars. The 76ers pop up a lot. Boy, do they pop up a lot. They've gotten a lot of trademarks over the years. And then at this point, you can say, all right, well, that's my result when it comes to the design code. But then you can put in you can put in one of those class numbers, the international class numbers, or you can put in, say you want all the ones with stars that had the clothes. So 025 was the international class for that. And you can say and. That's very important. And because otherwise you get even more results. So,
Now, if you have just say a company name.
I'm sorry, I couldn't hear you, Ed.
If you have a specific company name and you put it in there,
Yeah.
and if it doesn't come up,
Right, but here's why that's not the end of the process. Remember, it's all about likelihood of confusion. So say you put in the name timber. Well, timber is fine, but maybe somebody spelled it timber with 3 R's at the end. Or somebody spelled it T-I-M-B-R or T-I-M-B-R-R-R. All of those are variations that would constitute infringement if you put it into a similar class. So say you were doing sporting goods and they're doing sporting goods, they would reject it on that basis. And you're not going to get a refund for your application if you find that they have found a similar trademark.
It's sight, sound, and meaning. So what
Yeah.
Steve said, it's spelled differently, but it has the same sound,
Right.
the same meaning. So the example I give people is like, if you're familiar with Red Bull energy drink, there was a brand called Blue Ox. And so
Of course.
Red Bull shut down Blue Ox because that is unquestionably confusingly similar. Different words, but it's the same theme.
Right.
Color and a cow, or both my cow.
Yeah.
So that's the way you gotta think on a confusing similar. If it has the same sight, it has the same meaning, or the same sound,
Yes.
it's there. So when you don't find exact matches, you're not done.
Yeah.
So you'll have to be creative and start doing all
Yeah.
the searches
Because
using
it could be
different
different,
variations.
different words with similar meanings.
so how do you
Exactly.
know which classifications you want to be?
Well, the classifications are going to be based on which goods and services you're offering. So you want to look for people that are at least close in that classification. So yeah, it can
Yeah,
be
they
a
take
process.
Really expansive views of that, like
Yeah.
they look at goods that are sold in kind of the same distribution channels and marketing channels. So an example I give is like automotive motor oil and deerskin chamois. They're completely different products, but the trademark office would see those as crossover because they tend to be sold in close proximity. So that means that a deerskin chamois and a motor oil cannot have confusingly similar trademark.
Yes.
And so who gets priority? The one who had it first. They win and they can keep it.
Yeah.
But let's say that I got it first, but someone else has a lot of money and a lot of lawyers.
It depends if you
They might win anyway,
federal,
right?
if you have a federal registration, but normally it's the early bird wins on trademark.
Yeah. If you're doing really well with your 5-hour energy, don't try to, you need to make sure you clamp down on anybody who puts out 4-hour energy or 6-hour energy. It's just the way it works. You've got to be out there and be diligent.
And then, the other thing about that is if consumers are actually getting confused, like they're
right.
And your people are going, then, if that's happening, then you definitely
Yeah.
are too
I imagine
close.
there are people who get, the 4-hour, 5-hour drink thing, they kind of let it go, and then they lose their window of opportunity, either because the other one starts selling more, or in a court case, they say, why didn't you do anything until 5 years?
Yeah,
Yeah.
in essence,
Yeah.
sleeping on your rights.
Right. And there are issues about trademark dilution, you don't, you want to make sure that people don't casually refer to an energy drink as 5-hour energy, because that may mean that people will forget that it's associated with your business. It's the example that comes to mind, a Kleenex. Kleenex is going to defend their use of their tissue. So, that's going to be a problem if you just casually use it that way.
That's why on the box it says
Yeah,
Kleenex Circular brand tissue.
right.
So it's a branding association with the good. Instead of you don't want to just say Kleenex.
Yeah.
Whereas that's kind of a unique product because they really don't trademark the Kleenex itself. It's the
Right.
package.
Right.
So it's
Xerox
really
comes to
tricky.
mind. Did Xerox lose their trademark? Is that an example of trademark dilution reaching
a
a?
lot of them. I mean, cellophane and
Cellophane.
trampoline and
Yes,
Xerox had some risk.
that's right. Cellophane. Yeah.
It's, if you
they
go
lost
back
it.
to Old English, you can't let it be a noun. It's got to be an adjective.
Yes. So we've combined a design search code. We've combined it with a class. Here's the image list, and this might be a place to look. Here are people that are working in your area. They've got similar design. They've got similar goods and services. So this might be something to look at. And in our case, I really did this kind of at random, but we only got 209. That's not terrible. But
Yeah.
go
If
through
you
every
could
one.
Go back one screen.
Yeah.
If you look at that listing, you see the columns. There's the first one says serial number. So everything that gets filed gets a serial number, and then the second column says registration number. So when the registration number is empty, it's filed and pending and not approved, right? If it's live. If it's dead, somebody let it go.
Yeah.
So when they have a registration number, like the red one, that's been approved. So, you get a feel for, that's more of a bona fide trademark. The ones without registration numbers, you can look at them and see why maybe they were rejected.
Good point.
Give you an idea.
Yeah.
So there's only one there that's.
Well, in this case, they're more.
Yeah, I
Yeah.
mean, the newer ones are on the top, so there's gonna be more unregistered.
Yeah, they're grouped by the serial number, so they go in
But
reverse order.
Once they're older, if the registration number is blank, there was a reason it didn't make it. If it's close to
Yeah.
your name, you'd wanna know that reason.
Yeah.
How many pages are there?
I think 50 a page, so that would be 4.
I mean, just for that, how many pages are there?
No, for this one, gives you 100 on that page.
100 a page.
And then we can go to the next page and takes you to 200, and then finally the last one would have 9. And that's everything. And then you can look at them as images as well. So, well, I know I've thrown a lot at you guys, but this is in essentially the major points of what we cover in the appointment, and I will be more than happy to go over any of this, plus go into more detail when you come in. There's much more we can go into. But this is the essence of what we do at the appointment service, and essentially what you're going to be looking for when you start this process yourself. Remember, those full-text books are available at the Legal Information Reference Center on the library webpage. That will help. The Inventor's Assistance Center is there with former examiners there with a toll-free number to call to see if they can answer some of your questions about the process. They can't tell you if your idea is patentable and so forth, but they can certainly help you with the process and answer questions about forms and so forth.
Anybody would guarantee a patent.
Sorry?
I don't think anybody would guarantee a patent.
Nobody would guarantee a patent. Even your attorney wouldn't. But at least an attorney will give you an informed decision based on their searching and their experience as to whether it's worth proceeding and,
It's,
you know.
it's all a matter of the fight you have and your money.
Oh, gosh, yes,
I mean,
yes.
You can probably get a patent on anything if you keep pushing long enough, spend enough.
I like that optimistic approach.
Narrow coverage. And you know, the whole thing is you file and this process goes on for years, so you're constantly assessing commercial potential of this idea. And if it's not making it commercially, then of course you'll have to.
So I was telling him earlier, I found a webpage that said that they could get you a trademark in less than 24 hours.
I don't think they can.
I don't think you can do all that.
Yeah, you got to watch out.
No, that's, I'm sure they just need to file it.
Yeah, maybe so. There are a lot of organizations out there that are trying to rip people off. I just should mention that. There are patent-related rip-offs and there are trademark-related rip-offs. We can certainly talk about that more when you come in for an appointment. I even have some handouts on that. But you've got to watch out. I've had some people come in with some horror stories. You know, I don't want to name names, LegalZoom, but I just, you know, they've come in, they've paid all this money, and they were working with attorneys that weren't licensed before the USPTO, and they were working with material that didn't get followed up, and they lost their provisional, and I mean, it's just sad. It's just
They're
sad.
supposed to be so inexpensive, but I went through their site and clicked and clicked and clicked to get a patent.
Yeah.
I was an applicant. And by the time I finally got through to it, it was more money than most people charge.
Yeah.
So it
And
wasn't a deal at all.
I don't mean to, single them out, but I've had people come in with some stories about them, and of course, with other attorneys that they've had bad experiences with, and so forth. So, try to find somebody on the list. If you can, get someone through the pro bono referral service. You're good. You're good as gold. You're going to be able to get free representation through that for the entire process.
I interviewed them just like I was hired for the job. When I got a patent attorney, I interviewed some patent attorneys.
Yeah.
Just like I was.
Yeah, exactly. Exactly. It's an interview process. And another reason to do your homework ahead of time. You want to know what you're looking for. They're going to ask you questions, and you're going to have questions to ask them. And the more you know about this process, the better. You want to keep a handle on it. You don't want to just say, run this for me. It's a partnership.
Yeah, it's kind of, if the attorney can be creative enough to get your patent approved, and how you package and present the patent office and approach them. Because I've had people that didn't get patents, and we reformulated it, went again and got them, and
Yeah.
had other attorneys or firms tell them they couldn't.
Yeah.
So there's always different approaches. On trademark, it's a lot easier. You just pick a unique name, you're approved.
Yes. It is easier.
It's
a lot easier.
Yeah.
Yeah. More unique, the better. Google had it right.
Pick a name not in the dictionary.
Yes. Right. Random but pronounceable.
I've got to believe too that you can get the patent and still don't have anything anybody wants to buy.
Yeah, I've heard estimates that somewhere in the area of 80% of patents don't actually make it to market. I don't know exactly how accurate that is, but
You could even make 100,000 of them, nobody wants them.
that's right.
Because you didn't do your market research.
That's exactly right. Yeah. And keep in mind there's help out there around Denver to help you with that aspect of it as well. We refer people to the Small Business Development Center. They're downtown.
But Chamber of Commerce, or is it something else?
No, it's not. They're independent. I think they work with the SBA, Small Business. Am I correct? I don't want to speak for them, but
Associated more with local governments.
yeah, you're right. You're right. So
But
I'd want to
they're
refer you
kinda
to them.
They're resource centers, but they're not really going to help you put together a business strategy.
No. They have some classes that are free, some low cost, some expensive, but they do offer a wide range of services. And again, I do strongly refer you to Mikasa Resource Center. They have a lot for everybody. There are other services out there as well, you know. And remember, the library also has that Biz Boost service. You'll want to get an appointment with them when you're putting together your business plan. We have access to a database, I believe it's called Demographics Now, and you can get hard numbers on your target audience based on where they are and what their interests are and so forth. It'll tell
That's
you.
more for if you're gonna do something local.
Yeah,
versus
local.
on the web.
That's right. Yeah, if you're going national, it's a different story. But again, it wouldn't hurt to talk to those folks. We also have other resources that are library resources that might be useful.
The best thing to do is go to trade shows, national trade shows in your industry, meet players,
Yeah.
people who know that industry, and then they're the ones to partner with.
Yes. Yes.
Because you need someone who's experienced at your type of product and that distribution network, that sales network,
Right.
and how they do their manufacturing.
Every business, every market, every industry has unique aspects to
Businesses
it.
are all different.
Excuse me.
But yeah, you need to partner up with people and investors.
Yes. Is there anything else I can help with? Let me also just remind you that I've got some handouts for the Patent and Trademark Resource Center at that little podium there. And I also brought some handouts on the differences between different types of intellectual property. And it goes into some more detail than I've seen in a lot of other handouts, so I felt pretty good about giving it out. Oh, Roberta, you've grabbed one already, and yeah, it might be helpful. So,
Thank you very much.
my pleasure, guys. I hope that helped.